Mr. Boyer, who do you have with you?
Mine. Now wife.
Okay, and what is her name?
Hair Boyer.
All right from the start, the judge is setting the tone, identifying the parties and grounding us in what's clearly an old case that's now being reopened. That usually means something major happened, like a custody violation or a school enrollment issue. Let's listen closely, because this one's about to get complicated.
All right, this is a 2017 case, so it's an older case. Originally, there were two minor children that were the children of the marriage when you got divorced, and that was Cheyenne and Chloe. Chloe has aged out because she turned 18, correct?
Right.
Yes.
Okay. So the only child at issue is Cheyenne. She was born in 2012, and so she's about 13, correct?
Yes.
Okay. Now, when I look back at the file, what I'm showing, which I have to go to the very last court order, because it controls the case, the last court order that was entered. And what I ascertained was that on January 30th of 2019, you guys received a divorce. There was a decree of divorce. There was also a parenting plan that was filed and a supplemental holiday plan, and that was the last order that was entered by the court.
This section's important. Cheyenne is the only minor still under the court's control. That means every decision made here affects her living arrangements, schooling, and overall stability. And when a child is 13, courts walk a fine line between enforcing orders and considering their growing independence.
And it gave Dad primary residential custody of the girls. And again, we're only talking about Cheyenne now. She's the only remaining minor of the parenting plan. Mom got first and third weekends, 5 p.m. Friday to 5 p.m. Sunday. Fourth weekend, Friday to Saturday. I think it was 5 to 5, but it wasn't a full weekend. And then she was awarded winter break, spring break, and summer, where then you got the same coordinating weekends. So you flipped that when she had summer custody. Then on 7/23 of 25, Dad filed a motion to enforce visitation because he claimed that Cheyenne was not returned after summer visitation.
Here's where things get tense. The father says Mom kept the child after summer visitation, while the mother argues she couldn't force Cheyenne to return. This is one of the hardest situations family courts face, when a teenager refuses one parent. But the law still says orders must be followed until changed by the judge.
She was enrolled in school in Douglas, where Mom currently lives, instead of Eureka, where Father lives, where he, as the primary residential parent, had her enrolled in school. Service wasn't obtained. A hearing wasn't requested. One wasn't scheduled. In the interim, a motion to modify visitation was filed by Melissa on 8/6 of 25. Again, no service, no request for a hearing date to give notice of hearing. And it was alleged there that the child did not want to return to Dad and that Mother could not physically force her to return. And so here we are. There was a hearing on 9/30 by notice of our court because nothing had been scheduled to get this thing up off the ground. It is a serious situation, but as I indicated, all of the procedures have to be followed. But we did want to get you together to recognize that these motions are on file. They're conflicting motions, and get this thing scheduled for a full evidentiary hearing if necessary. Additionally, Mom asked that the child be heard, that the child wanted to communicate with the court. Now, please understand, there is no age in which a child can make their own decision. The court does often hear from a child or children. Generally, I never want the first recourse to be testimony or involvement in the litigation.
The judge is being very cautious here. While it's natural for a 13-year-old to express opinions, it's also dangerous to let a minor dictate custody. Judges prefer neutral third parties, like school counselors, to avoid emotional manipulation or pressure from either parent.
But I am allowed in chambers to visit with children by agreement. If one party wants it recorded, it has to be recorded. That is not, again, my first avenue. My first avenue is generally to have a child with a school counselor, a therapist, or an advocate who the child is entrusted to, that provides information to the court, not only about the child's wishes, but what that person sees in terms of the best interest. I mean, that person reconfirms for me that the child is mature for their age, that the child is taking a position for the right reasons, and that is quite helpful to the court.
And Cheyenne has been seeing the school counselor.
Okay. But I am, noting that for you in terms of I'm acknowledging that Mom has asserted that she has an opinion about where she goes to school and who she wants to live with during the school year. So, having said that, I'm probably going to, I want to hear from both of you as to your position on the record under oath. And so we'll go from there.
And there it is, the key mistake. Mom enrolled the child in a new school without filing a motion or getting permission first. That's a big no-no in family court. Even if her intentions were good, the court sees it as a violation, and that could come back hard when the judge rules.
Probably the result today is going to be that I make enter a temporary order and schedule the matter for a full evidentiary hearing in person to make a final determination. The preferred route for these things is that the child should have went home under the current order, and Mom, you should have filed a motion during the summer before school started to, one, give you custody of the child for the school year, to change physical custody for the school year, and to give permission to enroll her in the school, instead of not following the court order, keeping the child, making him file a motion to enforce. Now I'm put in a position of, one, starting with the premise that you violated a court order, but two, having to consider yanking a child out of school that a parent has put the child in school in violation of the court order. So I have to take all of those things into consideration and try to straighten this out and provide the least amount of disruption to the child and her life, but also act in her best interest with what little information that I have. Okay, so since the motion to enforce was filed first, I'm going to have Mr. Boyer, you go first. And if you'll raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay. Now, normally, thank you, in a court proceeding, there is an attorney who asks questions and an attorney or a party that can object to questions for various legal reasons. But because you're acting as your own attorney and you're a witness because you're a party, then there isn't a lot of latitude for the court to follow evidentiary rules as it relates to testimony. So if during the course of things, one or the other of you has an objection about particular testimony, you need to, in a orderly way, advise the court that you're objecting so that we can try to address it as best we can, given the nature of the self-represented proceeding. So, Mr. Boyer, you need to state your name and what statements you wish to give under oath with regard to Cheyenne not being returned to your care at the end of summer for the beginning of the school year.
Well, the last time I seen Cheyenne, Brian Boyer.
All right.
And last time I seen Cheyenne at my house was Wednesday, June 11th. Her mother come and picked her up from my house, and that was the last time I seen her. I was refused my Father's Day parenting time. All my weekends since then, I have not got. Cheyenne got to miss out on vacation trip to Branson with us because...
Okay, hang on. Ma'am, you're going to have to sit back on the couch and observe. You can't keep telling him what to say. Please, I'm sorry. Thank you. All right. Go ahead. What about your weekends?
I have not got any of my parenting time since then at all.
So what have you done to try to facilitate getting the child or enforcing the court order?
Well, for one, when she moved to Douglas, I do not have an address where my child's at. I have no clue. All I know is she lives in Douglas. Which it states in our papers too that if we move, you got to give a 30-day notice on a new address change. I haven't got one.
Okay. So what you're telling the court is you had no place to drive to.
I have no clue where my daughter's at, other than Douglas.
And did you contact the Douglas authorities, whether it's the sheriff's office or I don't think they have a police department, frankly. But
I talked to the sheriff on July 23rd about this.
I'm sorry. I may have interrupted you. I apologize. I couldn't hear you. Go ahead.
On July 23rd, I contacted the deputy that patrols down there, and we had a conversation on what to do. And basically, he told me to call her in as a runaway. But that goes on her permanent record, and I really didn't want that on my daughter's record.
Okay.
This is emotional. You can hear the frustration in his words. He's saying he hasn't seen his daughter since June, doesn't know where she lives, and feels completely shut out. For a parent, that's devastating. But from a legal angle, what matters is whether he can prove interference or parental alienation.
Did he try to locate where she was living, where mom was at?
No. Because don't know.
Did you, does she have her own cell phone?
Yes, but it is highly monitored by her mother. Every time I try to call her, you hear it click on record.
Okay, so did you talk to your daughter on the phone after June 11th about where she was at, where her mom was living, what residence she was at?
All they've told me is she lives in Douglas. They won't give me an address.
So how many conversations on the phone did you have with your daughter?
I've had probably 3 good conversations and a few text messages, Snapchats, but other than that, my daughter really doesn't talk to me anymore.
Well, what did she say to you during those discussions about weekends with you and that kind of thing?
Well, just prior court date on the 28th of August, that evening, Cheyenne called me and she stated to me that she wanted to come back to Eureka. She misses all of her friends. She wanted to come home. And that's multiple times that I've heard that from her. I've got a text or a Snapchat from her sister where she thinks that she blew this out of proportion and went too far with all this. So Cheyenne's recognized what she's done. And I just want my daughter home.
But are you talking about a child support enforcement action that was going on?
No.
Okay. All right. So on August 28th, she told you that she wanted to come home and go to school in Eureka?
Yeah, and missed all of her friends.
Okay. And when did school start in Eureka?
Well, it had been the 17th, I think it was. 21st? 21st, yeah.
Okay, so this was already past school having started in Eureka.
Mm-hmm.
Did you enroll her in school in Eureka?
Eureka wouldn't let me because Melissa had already enrolled her in Douglas without telling me that she's enrolling her in Douglas.
How would they have known that she was enrolled in Douglas?
Because Douglas School District contacted Eureka to get her transcripts from Eureka. Because Cheyenne's been in Eureka since she started school. She started preschool here.
Well, I think I would have shown, I would have went to Douglas High School and shown them the court order. So you never physically tried to go pick up your daughter at school or anywhere?
No, not yet. I actually faxed the court order down to Douglas, and he said I had no justification because of the wording of it.
Well, I mean, no court orders generally give precise dates each year, but when summer's over, that means the school year started, and you clearly had primary residential custody under those orders.
Yes.
So, all right. And so when is the last time that you have spoken with your daughter?
It would have been a week and a half ago, probably.
And what did she tell you?
We just carried on a decent conversation, and once again, she mentioned that she wanted to come home and she missed all her friends.
And just like that, the financial element drops in. Mom's behind on child support, which never helps her case. When custody violations and unpaid support appear together, judges often see a pattern of disregard for court authority.
So, have you checked with Douglas? Are you able to get into power school or whatever they offer to see what her attendance is and how her grades are and that kind of thing?
Yes, we can.
Have you done that?
Yes, I had to call down there and get access to all that.
All right. All right. What else do you want to tell me?
I think that's about it.
Have you been receiving your child support from Melissa?
Yes, I have. And just to note, she is, last I checked, she's like $3,500 in the hole. In rear.
Okay.